All right, back on the Zoom. Good afternoon, everyone. Let me call the case and ask for announcements for the record as soon as I call the case. P-37302, this is in the estate of Alberto Rene Montoya. We have announcements for the record, please.
Howard Reiner, attorney ad litem for the minor heirs, Your Honor.
Herman Ramirez representing Alberto Rene Montoya Jr.
Tomas Flores on behalf of Doris Rios.
Nancy Hamrin on behalf of the surety, State Farm Fire and Casualty Company.
Ms. Christie, your microphone's muted.
Sorry about that. I thought I unmuted. This is Lauren Christie, present as the successor administrator of the estate.
All right, Mr. Flores, I was able to hear you, but the insignia for muted, or did you mute and unmute, or okay, you're okay now. All right.
Okay, were you able to hear me, Your Honor?
Yeah, I was, and that's what I was a little perplexed about. But anyway, so good afternoon. Ms. Christie, I guess I'll let you take the lead and then tell me what you have pending today, and then anyone else who has a request for affirmative relief, tell me what they have, and then we'll figure out the sequence.
Okay, Judge, we've been set today on my application for authority to compromise or settle matters in dispute. All of the parties that are present today participated in a full day mediation on April 27th, 2021. During that mediation, we reached an agreement, but my ability to enter into this agreement and make it binding is subject to the court's approval and granting of my authority to enter into this agreement. I would represent the court that it is my opinion that this is in the best interest of the estate to settle the dispute here along the terms that are in the settlement agreement that we submitted. And I'm happy to answer any questions you have about the settlement agreement, or I can run through the terms of it if you'd like me to.
We'll come back to that in a minute. Yes, I would like for you to share that with me. But is there anyone else who has any pleading, seeking affirmative relief pending before the court this afternoon?
I do, Your Honor. I have an application to pay attorney's fees. Attorney ad litem.
There's also pending, Your Honor, the order on restoration of funds.
Okay, that's okay, I have that noted as for entry on the order of restoration of funds. I had one filed on April 23rd, and I have one filed June 9th. There seems to be some difference in them. I don't know what the differences are.
The difference, Your Honor, is that on the one filed yesterday, we stated that these funds would be kept in a separate account under a separate cause number, so as not to commingle this money with the estate's money. If you'll recall, this money was the community interest that belongs to Doris Rios, and that's being ordered to be placed back in the registry. So it's her money, not the estate's money, and we don't want to mix those two. So that's why, that was the only difference, is to order it deposited into a separate account, but still with the registry.
Is that undisputed? Is that solely what the source of all this money is her share of the community portion of the real estate sales that were authorized? Is that all that's involved in the CDs?
Correct, Your Honor. This is the money that was distributed to her out of the sales, so her community interest, and that's what's being ordered to be replaced.
Mr. Ramirez, you seem to be the one that would have the most direct interest in this. Have you reviewed the new order, and do you have any objections?
I do, Your Honor. First of all, you ordered the money to be commingled from the beginning.
Your Honor, can I ask Mr. Ramirez to fix his volume? I can barely hear him.
I was having trouble.
I was about to say that I can hardly hear you.
Okay, is that better?
Not really.
Let me see here. I'm sorry, Your Honor, I don't see an icon here with my volume. I have my speakers up high. Is that any better?
It's a little better for me, Mr. Reiner.
I think we can hear it, Your Honor.
Okay, let me speak up a little louder.
Mr. Quintanilla, are you able to hear?
I'll shout out if I can't.
Okay, thank you.
Anybody else? Is everybody else okay to proceed?
I'm good, thanks.
All right, go ahead, Mr. Ramirez.
Your Honor, from the beginning, you ordered the money to be commingled into the registry report. My concern is that there's going to be future expenses for administration. There's three other, I believe there's three, maybe four other properties that need to be sold. There's going to be expenses with that, and any other lingering expenses have to come out partially from Doris's money. So I don't want any confusion on her money being her separate money, and it just needs to be clean, one account. Now they're talking about a different cause number. Now there's more work for the administrator to get 2 or 3 orders based on the cause numbers. I just think that it's unnecessary. I mean, I don't see a reason. They're not giving me a reason why they want it separate. I mean, it's going to be accounted for. I mean, her money's going to come in, hopefully plus the interest. I mean, they haven't even talked about whatever interest she gained from that money. I mean, that money would have been ordered by the court to be put in a bank. The estate would have gained that interest. But anyway, I just don't see any reason for separate. I mean, I suspect there might be some problems later that she's not going to pay any fees because that's her separate money. I mean, she still has to continue paying expenses, Your Honor. I mean, this case is going to linger on a little bit on the sale of the properties. I think at the beginning, the lawyers were thinking of settling the property issue right away, maybe without further expense from the administrator. But that's not going to happen because there's a minor involved, and Mr. Reiner has objected to any buyout because, I mean, the minor can't agree to, sell his interest on real property. He's a minor. So that concern has come up with Mr. Reiner, and I kind of agree. I mean, he's putting himself out liable for any claim that minor might have later on. So I can see where he's coming from and saying, well, these properties should be sold, so that way it's just cash. So I just don't see why they have to separate. I haven't seen a good reason. I think it's cleaner to have one account instead of 2 accounts. It's cleaner to have one cause number instead of 2 cause numbers. I mean, that's even more work for the clerks.
Your Honor, may I respond?
Yes, sir. Go ahead.
And I appreciate Mr. Ramirez's diligence in working hard on this file. I do have to disagree. The problem we have, Your Honor, is there's money in the registry of the court right now that belongs to the 3 children, Mr. Ramirez's client and my 2 children. Today, Ms. Christie, in fact, nobody in the Zoom, Your Honor, can tell us what the interest is or what the balance of that account is. If we add the surviving spouse's money to that account, it's going to create an accounting nightmare. I'm assuming the clerk could sift through it, but it will be a problem when we go to account later on and distribute to the 3 kids. As long as it's under your control, Your Honor, and it takes your signature to release those funds, I see no problem with the money being in a separate account. And I think it should be in a separate account. At the end of the day, if Ms. Christie has, I believe, 3 pieces of property to sell, she sells one of them and there's property taxes that have to be paid. When we get to our net number, if it's community, the spouse is going to get her half net, not gross. She's going to be responsible for those taxes too. So there's not going to be any harm to her. I don't know what expenses the spouse is going to have to contribute to unless we run out of money and property taxes have to be paid. But at the end of the sale, the court knows that all the expenses of the sale are taken out of the sale before the administrator gets the net proceeds. So in jest, Your Honor, I think that the money should be in a separate account so that if there is any monies that they do need to come up with, we can take it out of that account. We're not taking it out of the kids' account. And Ms. Christie's not going to have a nightmare at the end of the day trying to figure out what belongs to the 3 kids.
What about the administration cost sharing?
Well, and I mean, I think that,
The continuing cost of administration.
and that can be, I mean, I think that can be settled if Miss Christie comes to the end of the day and she says, okay, the administrative costs were $2,000. And she's okay, Doris, the surviving spouse, is responsible for $1,000. We either give her $1,000 left when we go to close this estate, or Miss Christie gets an order from you to move $1,000 over to the kids' money. But Your Honor, if we keep adding to this one account and we have orders taking money out and adding, it's going to be an accounting nightmare. And I don't think the clerk is going to figure out what belongs to who for us.
It's the registry of the court. That's what we're talking about.
Yes, sir.
That's always what happens. All kinds of money goes in there.
Right. But I think the problem is we're going to have I think we're going to have a little bit different reporting than what they're going to have. Now, they may be able to say, okay, this was what you originally deposited. And the other point, Your Honor, is this money's earning interest. So the kids got money in there, and then the wife's money goes in there. Who's going to divide out the interest for the wife's percentage? They're just going to pay interest on the total amount, Your Honor. And so Ms. Christie would, as an example, Your Honor, if the estate had $300,000 in the account now that belongs to the kids, and the wife puts $200,000 in, the registry is going to pay interest on the $500,000. Ms. Christie will have to go back and figure out what percentage the $200,000 the surviving spouse gets in interest. The clerk's not going to do that for us.
My concern is that the amount of the interest that what you're speaking of, the interest to be paid on the registry of the court is negligible. I mean,
I agree with that.
If we get it wrong by 100%,
right,
to the other problems and issues in the accounting. How are the minors' interest prejudiced by not putting it into the registry of the court? Which, by the way, was my original order. Is that?
Well, the money's going into the registry of the court, Your Honor. It's just going under a different account number. They're agreeing. I don't think I'm mistaken here, Mr. Flores. Y'all are agreeing to put the money under a court order. It's just going into a different account.
That's correct. It's still going into the registry. And Your Honor, we've done this in other cases with multiple minors. Each gets their own cause number to keep their money separate, but it's all in the registry.
Yeah, and captioned how?
It would just be similar to an ancillary proceeding. It would be the cause number with a letter B after it. In re estate of Alberto, Rene, Montoya, and it would just have a letter at the end of the cause number. And we've done this with the registry before in other cases, Your Honor.
Well, we haven't had a case like this. So, I mean, I understand.
No.
If you designate money to a minor, in fact, I think you're required to set up a whole new account in the name of the minor once it's to be distributed to the minor, to sit there as like a payment to a minor.
Right.
But this is not the same thing. This is on ongoing estate administration. The basis for my ruling was that this is community assets that are subject to the court's continued jurisdiction, and that it should be back in the registry of the court. Where it changed or why it changed, I mean, that was my original order. And you were supposed to prepare a proposed order that reflected my ruling, and I set it for hearing for entry of order, assuming that it would pretty much be what I had ordered. Now, if it's by agreement of the parties and there are details that were worked out between the parties that don't prejudice anyone, but that assist in the continued administration of the state, I would be amenable to changes from my original order. But that's in light of an agreement. I don't see a reason to change anything if it's not by agreement. And I don't see any overwhelming justification for creating a whole new, I've not heard anything yet that persuades me to create a whole new -B. It's almost signifying that my ruling that it's subject to the continued jurisdiction of the court, her half share ostensibly of the community property sales are still subject to the court's administration. it kind of detracts from that in some way for some reason. And I don't see how you, by the way, get any protection out of this if it's in the cause number with a -B, subject to the court's signature. I don't know what you gain from that, except too overly complicated, in my opinion. The interest paid in the rest of the court is like nothing.
But Judge, let me just point out one other matter. The money in the registry of court right now is a separate property of the 3 kids. This money going in is community property. Now it's earmarked for the spouse, but if it's responsible for the community debts, I just think when we go to the end of the day, if Miss Christie has to get court order to take some of this money out, she's going to have to track all this. It's going to be additional work for her to track what comes out of the community versus what comes out of the separate expenses. If she has insufficient money to pay taxes, she's going to have to get an order for the kids to pay their share and for the spouse to pay their share. And it's not impossible, Your Honor. I just think it adds a lot of work to Miss Christie by commingling. Now, I don't disagree, Your Honor. Your court order was specific and it was supposed to be put in the registry of the court under this cause, and there should have been a motion to amend or do something different than what you had asked. I agree with that.
It's not separate property yet.
Well, the money, if we're putting it all back together, I don't think we have dollar for dollar what Doris took out. I don't think it matches the money that's in the registry of the court dollar for dollar. And that's one of the problems, because I think Doris spent some of the money.
Which is why I wanted to put it all back together again.
Well, and if you want it all back together again, then we're going to need to go back and match it and get the exact dollars back.
Well, that's the continuing accounting nightmare that we have had.
Right.
And I understood that this settlement, this broad, which I understood to be a broad settlement until I received a copy of Mr. Ramirez's objections to the settlement, that all that was going to work itself out in a total resolution of all pending issues as a part of that compromise settlement agreement. Was that never the case?
No, it works everything out with the exception of moving forward with the remainder. I believe, Ms. Christie, is it 3 properties or 4?
You're on mute, Lauren.
Sorry, I keep turning it off. I believe it's the homestead, the remaining Benson tract, the separate property Bryan tract, and the Jackson tract. So 4.
4 properties, Your Honor, we still have to resolve, but this settles all the complaints for the surviving spouse's administration and what she did with assets prior to that.
And why wouldn't the settlement include deeds reflecting the undivided interest whole? Why does it have to be sold?
Well, and it doesn't, Your Honor, and that's kind of the issue of what we're dealing with. Ms. Christie has recommended, and I don't necessarily object to it, I do have some concerns. She's recommended putting, one of the minors is going to be 18, I believe, in September, October, somewhere in there. We still have a young minor. Ms. Christie's view was, let's close the estate down and distribute the assets in their undivided interest, which under the code we could do. My problem is, Your Honor, who's going to be responsible for putting my minor's property, paying my minor's property taxes? I have concerns about the mother, the spouse, doing that on behalf of her child.
Your Honor, if I may, when we were at the mediation, we reached a resolution on, I guess, kind of the substance of the surcharge case, and we thought about maybe doing a second mediation for a resolution of the distribution of property. But I guess we just kind of treated them as 2 separate things. Let's get the surcharge dealt with first and past damages, and then we can move forward on how to resolve the rest of the estate, either in a second mediation or by agreement or just by distributing out.
Well, is it in the absence of an agreement that would be the way that it would be resolved, is the recognition of the undivided interest holdings of each minor? I mean,
Right. I think there was just some discussion about maybe we can, instead of dividing everything up exactly as it should be, maybe there's some buyouts that the parties want to do. And so we thought about a second mediation for that, but we just haven't gotten that far.
Well, to me, the estate distribution is the bigger issue. You seem to have gone backwards on this. I mean, the issue with State Farm is kind of just sitting there, waiting to be charged on the surety. But my concern is the administration of the estate and the resolution of the total estate. And if you don't have an agreement ending this, I'm not real excited about partial settlements. I don't understand why it would be beneficial to the estate administration.
Well, Your Honor, I don't think we can get to the second part if we have monies that are owed by the spouse and offsets, and we're solving a lawsuit. And Mr. Ramirez did file an objection, but his only objection to the settlement is that he wants to put his attorney's fees on. And none of us have a problem with him putting his attorney's fees on. If you accept the settlement today and sign off, the lawsuit, the surcharge is still open, and Mr. Ramirez can come put his attorney's fees on. And then the only thing we have left, Your Honor, is to try to resolve how to divide up the estate, whether Ms. Christie does a final accounting and passes out undivided interest, or we're able to divide up the property in a manner that's fair to all the heirs. But I do think we need to get the surcharge done. But in order to do this, Your Honor, we could not do this at the surcharge mediation because I can't tell you, Judge, the value of these properties, what the market is on these properties. Mr. Ramirez wanted to divide up the property, and on behalf of my minors, I can't tell you what a valid buyout would be for some of these properties. We're going to have some more work done.
Mr. Ramirez's claim for attorney's fees, would that be subject to the surcharge?
Yes, and in the agreement, Your Honor, we've provided a provision in there. It's provision F that allows Mr. Ramirez to put on his attorney's fees. And if the court awards his attorney's fees, they will be awarded against the surviving spouse, the administratrix, not against the estate and not against the bond. She's going to pay them.
That, Judge, is because the prior administrator has the funds and it's her primary duty to satisfy any obligations.
One way or the other.
Correct. But she's got the funds, so that's not the issue.
Mr. Flores, why would you be interested in settling without having this resolved on behalf of your client?
Well, Your Honor, it's really two parts to the case: the lawsuit, the claim for damages, and then the claim for attorney's fees, which is disputed. And then there's the finalization of the administration, the distribution, which really is not contested at this point. It really is more optional that we, come to some other arrangement than just an undivided distribution. And so it's not, I would say it's not contested. That portion of the case is not contested, but the lawsuit definitely was, and that's what we mediated and settled. And as Mr. Reiner said, getting that resolved gives us a clearer picture of what's left. And then hopefully we can, voluntarily and amicably find a way to distribute the rest of the estate. Or if not, we just use the default and give out undivided interest. But I think it's definitely will move the case forward by getting the contested matters settled and closed up. And by approving the settlement, it doesn't mean that we can't also settle the rest of the case. We just think it's better to do it in these two phases.
Mr. Reiner, this settlement includes a calculation of the losses incurred to the three children of the deceased.
Yes.
So we know, we know what the value of the estate should be now or should have been now, but for actions that are asserted by Ms. Rios. And so we know what 1/3 of the amount should be if they are made whole for each of the three children of the deceased, Mr. Montoya. We know what that amount is?
Your Honor, what we have is we've gotten all the records from the bank. We've gone through them, and essentially what we did is we objected to disbursements that weren't what we could consider not valid disbursements, or any monies that the administratrix failed to report from the rental income. So we've calculated that loss at $33,693. In addition to that, through the case law and arguments, we've also shown that Ms. Rios should pay the administratrix fees and some of my fees to make the estate whole again. So what we've done essentially is put the money back that we think was either not reported or improperly dispersed. We can't per se tell today, Your Honor, what should have been there or what we should have from day one, because there was a lot of expenses that Ms. Rios paid that were proper. She did pay property taxes. She did pay the mortgages and some insurance and things like that. So those would have been the normal deductions that any administrator would have gotten.
So when you say some of the administrator's fees and some of your fees, what are those amounts?
They're going to pay the administrator's fees that they're paying back, I believe, are $24,908.97.
Hold on. 24,907.
908.97.
Okay.
And then I've asked them to pick up part of my fees of $3,617.41.
They're picking up that portion.
Yes, sir.
Okay.
So altogether, Ms. Rios is paying, Your Honor, $62,219.38.
And that payment is going to be funded where?
That's going to be funded from Ms. Rios's money.
No, where? Where is it going?
Well, Ms. Christie will be paid her outstanding attorney's fees. The fees that you've already approved, she's been paid, will be reimbursed to the estate. The $33,693 will be put back into the estate for the kids. And my ad litem fees will be paid to me. In addition, Your Honor, Ms. Rios had several claims, and she's agreed not to seek reimbursement on any claims. And those claims were for property taxes, insurance, upkeep, various expenses.
And State Farm is paying what, if anything?
State Farm is not paying anything.
And Your Honor, but State Farm has a right to require indemnification from Ms. Rios. It is waiving that right. And as I indicated earlier, State Farm's obligation is only secondary to that of its principal. And if its principal can make the estate whole, then the estate's made whole and the surety doesn't have to step in.
So the question for me should be whether the estate's going to be made whole as a result of the settlement.
Yes. And we believe, Your Honor, given the money's paid and Ms. Rios walking away from her claims, I believe she has two pretty big claims, that the estate will be made whole.
So what happens to Mr. Ramirez's claim for attorney's fees?
Your Honor, according to the agreement in paragraph F, Mr. Ramirez is to file a motion and you're to consider what attorney's fees should be paid, and whatever you consider should be paid comes out of Ms. Rios's money.
Well, let me correct that. I'm sorry. Mr. Reiner, I don't think you've seen my pleadings in detail, but I'm asking for a jury trial on that.
Okay. Well, I'm just going by the terms of the settlement, and paragraph F says, does not preclude Alberto from seeking a termination from the probate court by motion as to Doris's liability for such attorney's fees. It says by motion. If the court interprets to give him a jury trial, that's the court's decision.
So, Mr. Ramirez, you would want a jury trial on attorney's fees that are reimbursable pursuant to the pertinent estate code section, or
Yeah,
I mean, if you're looking for attorney's fees for torts and stuff like that, I don't understand. Is this going to be a motion for summary judgment, Mr. Flores, or what's going to happen? I mean,
I believe that we'll require an evidentiary hearing, Your Honor, on the attorney's fees he's claiming.
you're asking, you have a billing statement. Tell me what the total of that billing statement is, Mr. Ramirez.
It's $47,750, Your Honor, on attorney fees, and expenses come out to $3,935.30.
And you're claiming some basis for recoverability other than the probate code section, the state code section?
I cited,
1.003?
right, I cited that and in the case.
You
Lord.
cited that in what?
I'm sorry, I missed that.
You cited that in what?
Oh, I cited a case. Lawyers, I think it's abbreviated, but I believe it's Lawyers Surplus Corporation versus Larson. It's in the application.
It's Lawyer Surety Corporation versus Larson, Your Honor. The fees are based on a surcharge, and they're based on the code section that if the administratrix breaches her fiduciary duty, they could be liable for attorney's fees. So I think what the court has to figure out in this regard is Mr. Ramirez's work that he did in bringing the surcharge initially and prosecuting the claim.
And making the estate whole.
Did you bring the surcharge petition, Mr. Ramirez?
I did originally, yes, Judge.
The surcharge
Yeah.
suing State Farm?
Well, we had,
He didn't name State Farm. He filed the suit against Doris initially, and then I intervened as the administrator, and then his claims were dismissed when I intervened.
So, Your Honor, I think there's a percentage attorney's fees clearly for Mr. Ramirez for bringing about the lawsuit and starting it. It's a question if there's any overlapping from Mr. Ramirez and Ms. Christie. And I'm sure Mr. Flores is going to be arguing some of it's overlapping.
That's the
issue.
The settlement agreement is State Farm is not going to be responsible for any of this.
That's correct, Your Honor, because Ms. Rios has the funds to pay whatever Your Honor determines should be paid.
And you're waiving your indemnity rights.
That's correct.
As part of the settlement agreement.
That's correct, Your Honor.
So we went a long ways to get you here, and
Right, but that's all right.
essentially State Farm is out if I approve the settlement agreement.
That's
Well, the
correct.
alternative, Your Honor, is if we move forward, Ms. Hamron would be charging attorney's fees, and then we would get Ms. Hamron to pay, and then she'd turn around and present a bill to Ms. Rios, having to reimburse it.
Yeah, at the end of the road.
Yes, so we're just cutting through that part, Your Honor, since she's got the money to pay. Very rarely, Ms. Hamron and I have done many cases together, and very rarely does she have principals that can afford to pay.
Yeah, and
So I think, Your Honor, what we'd like to do is, and we're moving forward, and it's not to say that we can't in the next month get this whole case resolved. It's just that I was told that they wanted to divide up the land. In all fairness to the miners, Judge, I don't know what this land is worth market value. We've got some appraisals, but in order to protect the interests of these miners, I've got to figure out what their land on market value is. An appraisal is one thing, but they don't always take into market value. So I think where we're at is we get the settlement agreement approved. Mr. Ramirez tenders either the motion or y'all agree to a jury trial, whatever. That gets resolved through your decision on what attorney's fees Ms. Rios should pay. And then Ms. Christie will file a motion to dismiss the lawsuit. And then we just have to close the estate out, Your Honor. But I would like some feedback from Your Honor as to your view for the miners of whether or not you would agree for deeds to go to them in kind of a Uniform Gift to Minors Act, with somebody overseeing it, making sure the property taxes are taken care of. I'm concerned about that. I mean, one of the miners, I think it's 12 or 14, And if he gets a piece of property, how can we guarantee that the property taxes and upkeep are going to be paid and we don't lose that property?
Your Honor, if I may, my thought on that was that the minors' share of whatever money they're going to receive from this estate will be in the court's registry and subject to withdrawal for payment of those kinds of expenses, at least as to the minor's share.
But when you do that, Your Honor, I believe, if I'm not mistaken, on the registry of the court, technically, doesn't the person asking you to release the minor's money to pay property tax have to put up a bond twice the amount of the release of the money and get a court order for you to release the money to pay the property taxes?
Yeah, I think y'all are way ahead of me in terms of the analysis of the issues. I'm not sure how much of a concern it would be for me.
I don't mind if we got somebody that we're all comfortable with that's going to be on top of it to make sure property taxes and upkeep are taken care of. I really don't want to see a minor own an undivided interest in property.
It's not the optimal situation, but in the absence of an agreement, that's what I fear we're left with.
Well, unless Ms. Christie sells all the property and distributes.
Yeah, or there's an agreement to sell with an understanding of what the distributions will be.
And she could sell some of them, Your Honor, and Ms. Rios can buy the estate out of the homestead interest. She owns half the homestead, so she could.
But I thought this whole settlement had resolved. I thought this is they will just sign off on all this and be done with the case. Now I have a jury trial on attorney's fees. I have a continuing administration, and I'm not sure. Maybe I need to know how much progress we made to accept such an unfinished product, I guess.
Well, Your Honor, I think we made huge process of getting rid of the surcharge that's been sitting for 2 to 3 years. And I think we had to do that to figure out what Ms. Rios owed in order to get to the next step to see what she's going to be able to pay for if she wants to buy half the homestead. But I think if you send us to mediation in the next 30 to 45 days, we can knock this out. This isn't a difficult issue. We just need to ask if people are in favor of selling the property, or if they're not in favor. If they want to do swapping, then we just need to get some information from some realtors, figure out what the values are, and go to mediation and try to do a swap. I think that's easy compared to what we've been through.
Is it possible then, Mr. Reiner, that your participation and appointment as ad litem and all that? At some point, I remember Mr. Lada kind of had the impression that he was going to get some reimbursements.
That's gone.
That's the reality that we've reached.
Yes.
Understanding of realities.
Yes, and
so the surcharge and the indemnifications and existing assets that are, I don't know, I assume they're subject to very aggressive collections, Ms. Hammerin. Does this money go to her and then you try to collect it from her later on, or how does that, when you have to collect on an indemnity, or is this so unusual that you don't really know?
No, normally what we do, Your Honor, is we put language in a surcharge judgment that says that when the principal, the administrator, gets her inheritance, the money that's owed to the bonding company gets paid out of that at time of closing.
So there's no way for her to avoid dealing with her indemnification provisions of her contract?
No.
If I'm understanding what you're saying.
Yeah. But I think we had to do it in this order, Your Honor, and we would have loved to try to do the whole thing. It's just that nobody had discussed at the time, dividing up the rest of the assets. And we were at, I think it was like 5 or 6 o'clock by the time we finished the settlement. So I don't think we would have had time that day. But like I said, Your Honor, I think the easy part is ahead of us.
So, Mr. Ramirez, you have a claim for attorney's fees that pretty much almost equates exactly what she's paying for damages. Am I understanding that correct?
Well, I think the damages total $60-some thousand.
And you're asking for how much?
42 plus expenses. It kind of equates exactly the figures that Lauren has on her fees. I think total was 40,000. Remember my math.
No, but you can't compare your fees with Lauren's fees. That's apples and
Well, she
Please
claimed
torque them.
she claimed some fees for for prosecuting the case. I can't remember if she combined the 40,000 with administrative fees, but anyway.
I think Lauren's fees came out to 24,908.97. Am I correct, Lauren?
No, my total statement was 40,933 as of the date, as of April 22nd. The estate had already paid 11,408 of that by court order.
Okay, and
And then another 13 was being paid by Ms. Rios, right?
Correct.
So you're getting 24,000.
Correct.
Right.
I'm sorry, go ahead.
So, Your Honor, the rest of Ms. Christie's fees are not chargeable under the surcharge. The Larson case, which Mr. Ramirez reflected to, it's out of Judge Herman's court, the Third Court of Appeals. And essentially that case says that the administrator will be paid all the damages for the surcharge, plus any attorney's fees to bring the case within the requisites of the code. In other words, getting the estate fixed. Ms. Christie has sold several pieces of property. Ms. Rios would have had to sell those also, so that can't be charged to her. That's new administrative work.
So Ms. Christie's attorney's fees, because we went through the step of dividing the attorney's fees. There's a proper legal term that I can't think of right now. Segregating fees for cost of administration, and then there's the fees in prosecuting the lawsuit.
Right.
Correct.
The cost of administration, portions of those are subject to the surety, and
yes,
portions and the lawsuit attorney's fees.
That's correct, Your Honor. And so we kind of put the negligence, the but-for negligence test. But for Ms. Rios's removal, Ms. Christie wouldn't have had to do an inventory. She wouldn't have had to do some of the steps that should have already been done by Ms. Rios that were done poorly. If Ms. Rios was still in office today, we wouldn't have an inventory by Ms. Christie. But at a certain point, Your Honor, when you're continuing administration, all that stops, and now you're doing things that Ms. Rios would have had to do anyway, so those can't be charged against her. They're new work.
And so Mr. Ramirez's recovery for his client is only going to be 1/6 of the 60,000. His damages would have been only 1/6 of the 62. That's the half of the third.
Judge, if I could, from my understanding is, and that's the issue that Mr. Ramirez is going to present to the court at some point in the future, either by motion or jury trial, and Mr. Flores will have the opportunity to respond. They're disputing what the proper amount of attorney's fees is that Mr. Ramirez is entitled to.
Your Honor, I think clearly Mr. Ramirez started the lawsuit. He filed the surcharge. He did a deposition and he did some other work.
I don't think he didn't file the surcharge.
Well, he filed a suit. He didn't serve the bonding company, but he did sue Ms. Rios. He started the lawsuit.
Okay, I agree with that.
And he did take her deposition. So he did some work up to the point where Ms. Christie got in. Then there was an issue where the judge had said, Mr. Ramirez, we already have an administratrix bringing the surcharge. The heirs aren't a proper party, so you're out of the surcharge suit now. So what the court has to decide is how much fees to pay Mr. Ramirez for his work on behalf of the estate.
So the 62,000 in damages is a number, or his
attorney's fees that he's seeking, you're going to have to review. It's my understanding, Your Honor, under the case law, you're going to have to review Mr. Ramirez's attorney's fees and decide out of those fees what was for the best interest of the estate and not for Alberto Jr., the third heir, because those can't get paid. So we're running along when he's originally doing the case, and he's gotten some fees for doing the work. And then when Ms. Christie got appointed and got in the case, there's a cutoff at some point. That's the dispute between counsel. Mr. Flores is saying they stop at a point way back here. And Mr. Ramirez says, no, I continue to bring value in the best interest of the estate.
The total estate, including her share, or the one half that was going to go to the kids?
Well, it would be, again, since it's against her, she's not getting any of that money. So, but that money's not coming back into the estate. It's going to Mr. Ramirez for his attorney's fees.
Yeah, the estate won't benefit from that
How I
money.
would value, in light of this settlement, how I should value the comparable value of those services. I mean, you can't give attorney's fees for $50,000 to recover $10,000. I mean,
And I agree with that, Your Honor. And I don't want to comment on Mr. Ramirez's fee application, but I think the standard here, you can look at the Larson case, but the standard here is what did he do for the best interest of the estate versus what did he do for his client? And I'm sure you've had cases where somebody's come in and said, I did this for the estate. And you said, no, you did it for your client. The estate didn't benefit. So I think it's what was the benefit to the estate for his work?
okay, and that would be the issue that Mr. Flores and Mr. Ramirez would find out.
That's going to be their argument.
I'm inclined to give you your jury trial, Mr. Ramirez, if that's what you want. I'm actually more comfortable with that, which is another reason why should I approve the settlement if I have the ongoing, an ongoing jury trial? But
Well, Your Honor,
I might be willing to do it if Mr. Reiner, you can persuade me that this is the best thing that can happen for the kids.
It absolutely is, Your Honor, because I need to end my involvement as a cost. Ms. Christie needs to end her involvement. And what we're arguing over is Mr. Ramirez's work that Mr. Flores has agreed. If the jury or judge says it's X dollars, they're paying.
Your Honor, I may.
Is that your agreement, Mr. Flores?
Yes, Your Honor.
They're going to pay it.
Yes, Your Honor. We're going to submit that to the court or to the jury.
No appeals? You're going to pay it? Is that the deal?
Well, Your Honor, the settlement agreement states that the money that's being restored into the registry, what we were talking about at the beginning of this hearing, that the money for attorney's fees is going to be paid out of that. So it's there.
And Judge, if I could read you a statement, at the end of paragraph F, it says, the probate court's determination on such motion shall be dispositive of any claim made by Alberto in connection with Alberto's intervention. Alberto agrees not to seek payment of attorney's fees from the estate or the surety under any circumstances. So whatever that determination is, Your Honor, Alberto has to accept.
Mr. Ramirez, just give me a little, what is your jury issue going to be? Do you know?
Just the issue of attorney fees, Your Honor. The jury's going to be able to hear the work that I did, whether it's reasonable. And of course, my fees are higher than Ms. Lauren because I think there's a difference in years of practice, 31 years compared to how many, Lauren?
6.
Oh.
So the jury's
Come
going to
on, Mr. Ramirez.
Well, I can't charge $50 if she's charging $200. All right, come on. I mean, it doesn't make sense. So that's an effect.
We all agreed to compensate Ms. Christie $200 an hour for lawyer work and administrative work.
We have. I mean, that's
I'm saying you're going to charge $50.
well. You're laughing. They're laughing because I'm saying that the years and practice doesn't make a difference or whatever. It does. The jury's going to know. Hey, somebody with more experience is going to charge more than somebody with less experience. Am I right or am I wrong? So am I going to argue $50? No, I'm going to argue more per hour.
That's the example that prompted the $50 comment is what prompted.
Well, I'm saying I can't argue $50. It has to be more than what she did. I mean, if you're going to cut my fees down and say, well, you're entitled to $50, I mean,
I'm not going to cut your fee down, Mr. Ramirez. I just want to know.
Your Honor, it's an example. I'm just saying, you know, I mean,
I want to know if I approve this settlement, what's going to happen. I don't have a problem with a 2 or 3 day jury trial with a verdict. If the verdict makes sense, I mean, if it's an enforceable verdict, if we're going to like come up with something that doesn't have any recognition in law or basis for law.
Your Honor, you're saying that no civil case has gone with a jury issue on attorney fees? I mean, that happens every day. There's a jury question for attorney fees.
No,
civil cases.
Don't take my words out of context, Mr. Ramirez. I want to make sure that what's left is going to wind up in an enforceable judgment that disposes of this case. I don't want to have an ongoing issue with that. And
one of the problems, Your Honor, that you might have with a jury trial on this issue is there's a question of law. And the question is, was this the best interest of the estate? And could it be charged, or was this for Alberto? And I don't know if a jury is going to be competent enough to do that. So the easiest one is this.
My whole point about the third and the sixth and the total damages, that issue right there.
Right.
Because if he did for his client, he can only recover damages that his client has incurred.
Right. But obviously the question is reasonable and necessary. But the second question is, okay, Mr. Ramirez incurred them, but did he incur them for Alberto or did he incur them for the estate?
Yeah, it's a question of the applicability of the statute, Your Honor. The 351-003,
That's another issue. No, that's not the same thing. That's just.
Well, I think
that's the statutory basis for his attorney's fees claim, Your Honor. And the legal question is, to which of those fees does the statute apply? And that's our argument, Your Honor. Aside from the reasonableness of the fees, it's to begin with, does the statute even apply to what he's requesting? So for example, he's charging fees for reviewing the closing documents and some of the sales of the properties. Clearly that had nothing to do with Doris's negligence or the lawsuit against her. So this is kind of an example how some of the fees are not covered under the statute.
And you're willing to throw that. Well, did your settlement, you want me to consider the settlement agreement, understanding that I'm inclined to give him a jury trial? Does that change your view of the settlement?
Well, Your Honor, the jury trial was not requested until after the settlement. So that was not contemplated. Our reading, or at least my reading of the settlement agreement, is that we were going to submit that issue to the court. And I'm still prepared to argue that the court should consider at least the legal question of which of those fees are covered by the statute. And then if he still wants a jury trial on the reasonableness of those fees, then that's fine.
Okay, well, I want you to understand that I'm considering approving the settlement agreement with the expression that I'm going to honor, that I'm inclined to honor his request for a jury trial. And that's where I'm saying,
I don't think that's
a judgment that's enforceable and dispositive in this litigation.
I don't think the jury trial issue is before the court today, Your Honor. He filed an amended pleading after the settlement.
The settlement approval is before the court right now. And that is, I'm giving you an opportunity to tell me no, then the settlement is blown. Or do you want to continue with the agreement with a clarification that now there's a jury trial request and I'm inclined to grant it? Do you still want to proceed with the settlement agreement with that understanding, that clarification that you're right, was not clear at the time?
I think there's separate issues, Your Honor. It's still yet to be determined. And we still stand by the settlement agreement as written. And if we object to the jury.
If I don't approve it, it doesn't mean anything.
The what? I'm sorry, I didn't hear you, Your Honor.
If I don't approve it, it doesn't mean anything. It's not an enforceable agreement.
Right, Tomas, what Your Honor is saying is that he's inclined not to approve the settlement unless we make a modification that Ruben's fees can be determined by jury trial. I think even if it is jury trial, the court is still going to have to give appropriate instructions on the legal matters. So the jury is only going to be considering the reasonableness of the fees, and the court will instruct the jury as to the legal matters that apply.
And I don't have a problem with that, Your Honor.
So when you envision tracking the 351.003 limited statutory basis for attorney's fees?
Yes.
Plus, yeah.
Your Honor, I may.
Yes.
I haven't been able to talk much, and I apologize. But there's a couple of things that came up. They're not in my objection because it just came up recently. My client, first of all, my client didn't sign the agreement. Okay, that's one thing that he's complaining about. I forwarded to him. He was in Roma. He was going to sign the next day. That just never happened. That's one. Two, after he read it carefully, after I don't know how many days it took him to read it carefully, if we look at paragraph B, the last.
What would that be in your objection, Mr. Ramirez?
The objection?
Yeah.
I'm getting to it. Paragraph B, the last sentence is any remaining fees and expenses of administrator incurred after April 22nd, 2021 shall be paid from cash belonging to the estate. And he asked me, what does that mean? I said, well, that means that Doris is not going to pay any more administration fees. And if this case goes on for another 6 months or whatever, and there's a bill of 10, 15,000 or whatever, that means Doris is not going to pay any of it for administration fees, nothing to do with the surcharge. So he says, I can't agree to that. And then the next one, C, it says remaining fees and expenses of the ad litem shall be paid out of cash belonging to the estate. Now he's saying, why am I paying for my brother's attorney? So 1/3 of Mr., and we thought it was going to be $3,600, but it turns out to be more than that because he's asking, I think.
You're breaking up.
Okay, I'm sorry. He's asking for, was it 11,000, Mr. Rene now? Or 12,000?
9,235.
So the kids would be charged 1/3, initially 1/3 of that. My client, 3,000 plus, with Doris not paying anything. And that's work that Mr. Howard worked real hard on this file.
Was that in the settlement agreement that you signed, Mr. Ramirez?
Yeah, I signed it with a space for my client.
And
Your Honor,
Your
the
Honor,
issue of his client being available to sign it was explicitly brought up. He said that he had the authority to sign for his client. We brought this up to him before he signed and agreed to this. This is the first we hear that his client doesn't agree or didn't give him authority. I mean, that was a blatant misrepresentation to the rest of us, Your Honor, by Mr. Ramirez.
As compared to them going to mediation without me, oh yeah, that's a big difference.
Well, Your Honor, there was a lot of this said, and we all understood, and to hear it today, and these statements were made that his client was in agreement. And we adjourned mediation at an expense, and this was a court-ordered mediation, Your Honor. And so if Mr. Ramirez's client refused to sign this and left mediation, you know, I think that's sanctionable, and I think there's attorney's fees that need to be paid for that.
Sure, this is the first time I hear anything about this. We were talking about attorney's fees.
Right,
Is it your position that you oppose this settlement agreement as we stand here today?
yes. Not only the objection I had earlier, but now these new objections that just came up.
You did, I can't hear you, Ruben.
Okay, not only the objection that's on file, that I filed May 26th, but there's new objections that come up.
But why hadn't you brought it up to me before? I'm sorry, we've gone through a whole hearing here.
Your Honor, I tried, I said, Your Honor, can I speak? And then went on something else.
Your Honor, we are all in shock to hear that Mr. Ramirez is basically saying he signed the agreement on behalf of his client, but now he's telling us he didn't have the authority. He specifically told us at the end of the mediation he had authority. His signature appears on the paper.
And Your Honor, I would point out that we removed any signature to be signed by his client we relied on his statement that he had authority to sign for him.
And moreover, Your Honor, this wasn't the first reiteration of this settlement agreement. We had printed out probably 6 or 7 of these that we all took 10 or 15 minutes and sat down and read. Mr. Ramirez has read this agreement or variations of it probably 3 or 4 times. In fact, we took a break at one point with the mediator. His Honor was nice enough to do it, so we go read it and came back. But the other point, Your Honor, is if Mr. Ramirez wants to bring his claim, I know the court can agree on this settlement agreement without Mr. Ramirez. Ms. Christie is the proper party to bring the settlement agreement.
So long as
That's correct, Your Honor.
So long as my objection's in the record, Your Honor, you can do whatever you want, but I'm telling you what my client has expressed to me now after looking at this. Now,
Mr. Ramirez, your client wasn't at the mediation?
he was by Zoom, Your Honor, and this was presented to us about 5:30 in the afternoon.
The last one, we had several of them, Your Honor.
Well,
Okay,
We
so
went through it together.
he was with you at the Zoom hearing on the mediation? He was with you?
he was at his home. You mean on the screen? He was
Sorry,
at his home.
okay. All right. So he was at his home and you were in his office. And you agreed to this and you never got his assent to that agreement?
Say again, Your Honor?
You agreed to the settlement and you never got your client to agree to the settlement?
Your Honor, he was supposed to sign it after I signed. That never happened.
Well, we were told you had you said you had authority to sign and that you would also go ahead in the next couple of days and get his signature, but we changed the settlement agreement to provide for your signature on behalf of your client.
Well,
So I have two views. One is a lot of times lawyers will settle, the clients kind of are not. So the lawyers settle it. Another view is the lawyers settle it, and then the paperwork comes in, and there's all kinds of new stuff in the settlement agreement, like this restoration order. I mean, I did not order this restoration order that was sent to me. So that's a big deal. If one side adds a whole lot of stuff to a settlement agreement that never even was brought up, then I don't know that you ever had a deal. I mean, that's so many differences and so many modifications. It's almost a material breach of the agreement not to add so much new stuff when one side goes up and thinks of all the neat things they think they want to have in there. I mean,
Right.
That's a clear cut issue for me.
Right. I'm sorry, Your Honor.
Go ahead.
We actually talked about that at the mediation. We said to each other, okay, do we want this to be the final settlement agreement, or is this just something that we then prepare a final settlement agreement from? And we all decided, no, this is going to be the final settlement agreement. So that's why we stayed and we circulated several versions. Lauren was the one typing it on her machine, and she would email it to everybody, and we'd all look, we'd provide comments, she'd make the changes. It was then put into a final version, and we all signed it. And we've never planned to go back and prepare new additional documents. This is the settlement agreement.
And
Your Honor, I'd point out that the last change to the agreement, if I'm not mistaken, was Mr. Ramirez's authority or right to come in and get his attorney's fees.
Your Honor, if I may,
Yes, sir. Go ahead.
for example, any other mediation that happened before pandemic, right? Because this Zoom thing, sometimes it works, sometimes it doesn't. Before the pandemic, if my client was in the room and he told me, go talk to the mediator and tell him we've agreed, okay. I go sign, come back to him and says, look, now we need your signature. And he says, you know what? I changed my mind. I'm sorry, I changed my mind. I can't, let's say custody. I can't give up my kids. It's just too strong. I need to keep my kids. And then I go back to the mediator and say, hey, you know, it didn't happen.
That's not the case here, Your Honor.
Real similar.
This is not similar.
He can change his mind and not sign. I mean, that's what happened. And I'm informing the court what happened.
I'm really shocked that you bring it up at the very end.
Well, Your Honor, you were already inclined to say, you were making comments saying, well, I'm not going to accept this. It's partial. You're already inclined not to accept it. So why am I going to bring this up if you're inclined not to accept it? Now that you're talking about, well, I'm going to accept it and then let the jury decide on attorney fees, well, then I have to bring up these objections. So at the beginning of this session, you're already thinking, no, you know, there's the change in the order and then
crossing your fingers, hoping I wouldn't.
yes, probably
even if you got your attorney's fees, jury trial, you're hoping I would not approve it.
If you didn't accept it, I would have my jury fee. I mean, my jury trial. I mean, my fees through the jury trial. If you didn't accept this, I mean, it's still open. You know, I can still argue that.
Yeah.
So
when was he going to tell us that his client disagreed? When was he going to tell us that his client didn't want to accept that?
Your Honor,
You didn't include it in your objection. That was my first.
I started talking between the time that I filed the first objection because I told him I was going to file that.
Well, the one I received is what I'm talking about.
What's that?
The one I received.
Your Honor, the problem I have with this and what we've done is we went through hours and hours of massaging this document. His client was there and participated.
Your Honor, we never even got into the room where they were talking.
You talked to your client at length.
They gave it to me at 5:30.
Based upon this document, Your Honor, based upon this document, Ms. Christie has gone to the effort and time of drafting an application to come and settle. We've had another Zoom to go over other issues that Mr. Ramirez was raising about not wanting to have this agreement approved. We spent now we're spending thousands of dollars amongst 4 or 5 lawyers Mr. Ramirez, if his client did not agree to this after he got off the phone with him, he should have filed something immediately.
Well,
And
here's what this is a settlement agreement that the objection to proposed settlement agreement that I make reference to, Mr. Namid, is that you filed May 26th, on or about April 27th. That was about a month before May 26th. All interested parties attended a mediation, and all but one issue was settled regarding the surcharge claim in this matter. The one issue remaining is the attorney fees claimed by Alberto Rene Montoya Jr. and against Doris Rios. So when you filed this on May 26th, had your client already told you that he did not want to agree and would not agree?
No, I hadn't talked to him about the last two issues that I mentioned until after this document.
Until what?
Until after I filed this document, the May 26th, because that's when I started talking to him about this objection on attorney fees. And then he started saying, hey, you know, how about these two paragraphs of this?
I'm going to put you under oath on this. Let me ask you right hand. Will you swear or affirm testimony you're about to give will be the truth, Mr. Ramirez?
Yes,
Sir, are you saying that when you filed on May 26th, when you filed this objection to the proposed settlement agreement, at that time your client had not told you that he did not agree based on those continuing obligations, or based on the fact that he was going to have the kids were going to have to pay all the administration costs and the other things that you mentioned earlier? Based on that, he told you after you filed your objections that I have in front of me?
yes, Your Honor.
Okay. Any questions anybody wants to ask him on that fact?
Your Honor, I got some points to make about his comment about his objecting to it. He's objecting to obviously the statement where my additional fees will be paid out of the estate. I don't think my minors should be charged with the excess fees that are coming out of the estate because I brought value not only to my minors, but to his client. No disrespect to Ms. Christie or Mr. Ramirez, but I don't think either of them have ever done a surcharge. I've done over 150 of them, Your Honor. And when I got in the case, I went and got bank records. This benefited all three heirs, not just the two minors. And I do not believe that the minors should be tagged with my attorney's fees only for a benefit I brought to the estate. Secondly, Miss Rios is not liable for all the debts of the estate. She's liable for the debts that are associated with her community property interest. The separate property interest of the decedent is not her debt. It'll never be her debt. I mean, you can look at the Constitution and say a third party can't be liable for the debts of somebody else. So the most that Miss Rios would have to continue paying in this, Your Honor, if it was a piece of community property and taxes had to be paid and the property is sold, well, taxes will be paid. She's only getting half after the payment of the taxes. I don't know what Miss Rios will be tagged for in the future going forward or what she can be tagged for. Only things associated with the property she has an interest in. She's not liable for the attorney's fees of the estate of Miss Christie.
Okay, any comments from any or any questions, Mr. Flores or Ms. Hamlin or Ms. Christie on Mr. Ramirez's testimony? I just want to make record that I've given you an opportunity. If you don't have any questions, it's fine.
Sure, I'd like to ask a question. Mr. Ramirez, didn't you state at the mediation you had authority to sign the mediation agreement for your client?
Yes,
And that's why you did in fact sign it on behalf of your client, correct?
correct.
I have nothing further, Your Honor.
Ms. Christie, do you have any questions?
I don't, Your
Mr. Flores?
Yes, Mr. Ramirez, at the time that you represented the mediation that your client agreed to the settlement agreement, had you reviewed it with him?
Yeah, I'd send it to him.
And he represented to you that he was in agreement with the settlement agreement and authorized you to sign it?
No. I gave him the terms of the agreement. Can you hear me, Roland?
Speak up.
Okay. I gave him the terms of the agreement. After I sign, I send him the forms. But based on my communication with him, he gave me authority. And I instructed him to sign and send it back to me by email the next day. I never got it. Now, let me correct something. Before I filed this objection on May 26th, I did try to contact him and trying to get that form signed. And he never responded. And I couldn't get that signed. So that was something that came up during the first conversation. I said, hey, how about that signature that I needed? I said, well, I'm not going to sign because I have these questions. I said, well, what are they? And that's when the conversation started about these 2 points that I brought up.
Okay, when was that conversation? When did that?
Your Honor, I'm sorry. I'm going to have to look.
Was it before or after your objection?
No, that was after.
Okay.
That was after, like I mentioned before, the conversation about the 2 points happened after I filed my objection.
Okay.
But the conversation about the signatures were taking place before I filed this objection. He hadn't signed it, and I kept looking for that.
So before you represented to the mediator and all other parties in mediation that you had authority to settle for your client, had you received authority from your client?
Yes, verbally, but he hadn't seen the form.
Well, Your Honor, if you'll notice on the settlement agreement, I signed it on behalf of State Farm because State Farm authorized me to do that, and the parties accepted my representation that I had authority, just like we all accepted Mr. Ramirez's representation that he had authority. And if now his client is basically trying to, that's the whole reason why we sign mediation agreements at mediation, so that we have an enforceable agreement.
Your Honor, also, I want to point out that even though Mr. Ramirez has objections, he's not a necessary party to this settlement agreement. The only necessary parties to the settlement agreement are Ms. Christie and Ms. Hamrin and Ms. Rios.
What is Ms. I was going to ask you to expand on that. I've always considered Mr. Ramirez in light of his original filing of the lawsuit, his removal, but that he actually agreed to, because the law said he could sue it when the original administrator was the person.
Right. That's correct.
He could pursue that lawsuit.
That's correct.
Mr. Lada's position had always been all along from day one, he had no authority to do that. But
because there was an administrator, Your Honor.
Yeah, but the administrator was the accusee.
Right.
Okay, so I've never agreed with that position. So, and then when we did get it, the administrator, when we got it removed, the administrator appointed, then the case law was, once you have an administrator, that's the person that has the authority to continue the litigation. So he was not only an indispensable party, he was the activating party. Now, once I removed him, or I don't know what the word was that I did.
You dismissed his lawsuit, Your Honor.
You dismissed his lawsuit with prejudice, Your Honor.
And really, his only issue now is the fees, which has been preserved.
Protected.
Mediation agreement.
It's protected.
It's protected.
Well, he has a continuing issue. How is okay? He's protected.
So, Your Honor, in essence,
I always considered him an indispensable party, which is why I didn't accept the first mediation that was done without him there.
Right.
Because he's always been in this case. He was removed with his acquiescence because the case law was clear that Ms. Christie is the one that had the authority to pursue the litigation for the estate, for all the parties of the estate, which makes sense. And the pie of the damages is more appropriately just, not just his client.
Right.
The minors were now in the claim. So
Your Honor,
I've always considered him indispensable, or what was the phrase you used? Disinterested or interested?
he's not a necessary party to this lawsuit, Your Honor. In essence, the way the law works, Your Honor, is an heir can bring a lawsuit where the administrator hasn't brought one or refuses. But once the administrator brings the lawsuit, the heir is no longer a necessary party. I can furnish you case law that points to that.
I granted the motion.
And so here's the way I believe this works. And I've been through this lots of times with Ms. Hamrin. as a successor administrator, I would bring the surcharge suit against Pryor and the bonding company. I would go to mediation without the heirs. I would settle. And when I file my application to compromise and settle, that's when the interested party heirs, Alberto Jr., come in and file an objection to that settlement, Your Honor. It would be your decision whether to say, okay, I grant the objection, y'all go back to mediation, or, you know what, Mr. Ramirez, your cause of action's against Miss Christie if you don't like what she did in this settlement.
Okay, substantively, I don't see a distinction that the end point of that makes sense to me, that the heir always has a right to participate eventually, whether
Yes.
it's for the mediation or after the mediation, they have a right to, and there was an objection filed here. So,
And that's the purpose of the application to compromise, is to give the heirs a chance to come in and object.
so they would always have an opportunity, whether they participated in, and it would be foolhardy to do a mediation without participation from the heirs if it was.
Well, typically the heirs don't participate. You could have 20 heirs and you're not going to drag them all to mediation. They have an opportunity to say, we don't think the settlement's in the best interest of the estate, because that's what the standard is, not whether an individual heir likes it, what he's going to get. It's whether the court thinks it's in the best interest of the estate.
Yeah.
Your Honor, I would have to say in my 31 years of doing surcharges, this is the first time I've had heirs participate.
Likewise.
Your Honor, we participated because of all the bad things the first administrator was doing, and we couldn't trust anything she was going to mediate.
Well, is this the first lawsuit where you're involved, Mr. Reiner, where the heirs initiated the litigation?
No, it is not. But once the new administrator got in, I actually have one right now, Your Honor. I represent 4 heirs. We're suing a current administrator. So it's not the first rodeo. Now, if that administrator resigns and somebody else gets appointed, I recognize that we have to turn over the suit to them. And I'm left, if I don't like how they did the suit, I'm left to an objection. And in this case, Mr. Ramirez, if Alberto doesn't like what Miss Christie does, he's free to sue Miss Christie on her bond. That's
So, Mr. Reiner, if your point is that the basic settlement should be what is in the best interest of the estate.
yes.
If you all, I guess I was wondering if the settlement, because he was involved actively, you never could have negotiated. No, you're screwed on your attorney's fees. Pardon my phrase there, but you all couldn't have agreed. No, we're not going to deal with your attorney's fees. We're just going to settle the best interest of the estate.
What I would have done in this case, if Mr. Ramirez wouldn't come to mediation, is I would have had a paragraph like paragraph F that we put in to protect him to go put on his attorney's fees. I've done that with Ms. Hammer before, where we've had to protect somebody else's attorney's fees.
He's protected under this agreement.
On the attorney's fees.
Yes, he's protected. We're hearing for the first time that they don't like 2 other paragraphs. And I believe, Your Honor, you can look at those paragraphs and say, you know what? I don't agree with your objection because, one, the estate benefited from Mr. Reiner's work. Mr. Reiner was the one that actually got the bonding company, although Ms. Christie tried to get him in. It was me that finally got him. And I was the one that went and got the bank records with the court reporting service to get the records. His other complaint is.
I'm persuaded about that, Mr. Reiner, but the other one is
Ms. Rios?
the issue about the administration costs, that the minor kids, the kids are going to have to pay all continuing administration costs.
Your Honor, everybody's paying all the administrative cost out of the community property because the law is clear. Once somebody dies, you get the property subject to the debts of the estate. So if we have a piece of community property and there's $10,000 owed on it, $5,000 is going to be charged against Ms. Rios' half and $5,000 is charged against the estate's half.
Well, I understood the language excludes that.
No, it doesn't, because if there's property taxes and we go to sell the property, we're going to get a net number. We're not getting a gross number. The property taxes are going to be paid, and Ms. Rios is going to get her half out of after the payment of the debts. Ms. Rios,
the most simple example is Ms. Christie submits an administration cost for payment of attorney's fees from that is time from today to a month from now. Clearly administration costs that that's be borne by the kids.
Yes, that's not Ms. Rios's debt unless it can be associated with community property.
Your Honor, if I may, the community property in her division is
the community property is subject to the estate. The estate has not been wound up.
That's correct.
Why is she continuing to pay?
It is coming at
distribution costs.
Because the community asset, Your Honor, if you take $100 and say $50 is Ms. Rios and $50 is the estate, and Ms. Christie is managing it, then she's going to pay her attorney's fees out, and Ms. Rios is going to get a net number. What that paragraph says is Ms. Rios is not putting any more money in to pay the debts. It's going to come out of the estate. Ms. Christie's got sufficient assets in the estate to pay all the debts to finish this.
Or for example, Your Honor, the fees associated with preparing an annual account, it's purely dealing with the administration. Ms. Rios would not have to pay half of Ms. Christie's fees for preparing the annual account.
Well, she would. I mean, yeah, that's the
She
point.
would not.
I mean, it's going to be paid out of money. That's why I wanted to put all the community property back into the estate, because it's going to come out of the whole pie.
Well, they would come out of the estate share, Your Honor.
Well, that includes her half.
That's correct. But it's what's being managed in the estate by Ms. Christie, because there's still community in the estate.
Well, yeah, but Mr. Ramirez, so the term of the agreement is only that you're not going to go send her a bill for half of the administration costs, although it's going to be charged to her share.
It's going to be charged to the estate as a whole.
In the final accounting.
Yes.
That's not.
Or based on the agreements that are reached.
So as an example, Your Honor, if the estate sells 100,000.
Or allocated, Mr. Ramirez, allocated to her half or paid out of her half?
I'm getting confused on all that. It's a lot easier to have one account and all the expenses from selling a property, for example.
So you don't know the answer, Mr. Ramirez?
What's that?
You don't know the answer.
I don't know the answer, really. I mean,
settlement agreement. Do you have a settlement agreement that you objected to in front of you?
I want one account. That's why I wanted to, her to pay her fees.
What does M or N say, the term of the agreement that you objected to?
I'm sorry, I didn't hear that.
What is the provision M or N or O, the provision you objected to, that your client objected to?
Okay, on again, paragraph B, page 3, the last sentence says, any remaining fees and expenses of administrator incurred after April 22nd, 2021 shall be paid out from cash belonging to the estate. Now, remember, they want to do two accounts, one for the estate and one for Doris. Does this mean that Doris is never going to pay any administrative fees?
No, it's not what it says.
Well, I mean, that's what
there is still assets. There's still community assets in the estate that are under the control of Ms. Christie.
Mr. Ramirez, the administration costs chargeable by Ms. Christie have never been paid by Ms. Rios. And they have always been paid out of the estate, which includes her half. So it's not really a difference.
Well, all I see is her money was never in the account, Judge. It was always out in Lone Star Bank. So it's barely going to come in, but I'm not too sure if she's paid anything.
It's just barely going to come in. Well, it took us a while to get here, Mr. Ramirez, but I worked real hard to get it back because I thought it needed to be there.
Right.
I thought there'd be a deficit.
That goes to the point that Mr. Flores is making, that it stops when you dismiss my client's case. But I'm the one that petitioned the court to get that money back in the benefit of the estate.
Okay, don't change the subject.
Well, I mean, I have to go back and say, hey, the work that I was doing was for the benefit, even after dismissal, was the benefit of the estate.
The attorney's fees is a separate issue that I don't necessarily am uncomfortable giving you everything you asked for, but that apparently wasn't enough. So, but
Your Honor, I think we can all agree there's certain expenses of the estate that the surviving spouse, even if it's community, is not liable for. We know that funeral expenses are never the debt of a surviving spouse, they're the debt of the estate. And separate property expenses for property taxes, insurance, does not get tagged to Ms. Rios because it's not her property.
Well, that's a distinction. That's a distinction that needs to be made when it's authorized to be paid and when the final distribution. I'm
Right.
dealing with this not on a case by in a specific example. I'm dealing with the generic. That Mr. Ramirez, that term doesn't tell me that she's not going to share in the cost of continuing administration.
Okay, well, we can track it. I'll be sure to track it at the end, Judge. I mean, that's fine. If you want to overrule my objection and that paragraph, let's look at the second paragraph. Remaining fees and expenses of the ad litem shall be paid out of cash belonging to the estate. So that means that my client is going to pay 1/3 of $9,000, which I think, why should my client pay his brother's attorney fees? It either comes from their fee, their estate, their own estate, or from Doris, because Doris is the one that caused all the problems.
No, that was an obligation that was defined at the point of the agreement, the 9,000.
Yes, sir.
No, we didn't know that. I never,
We didn't know about ongoing
all we knew was
This about-
$3,000.
lighting fees later on, or lighting fees as of the date of the settlement.
Apparently it was later on. I thought he had settled for $3,600, but I thought it was.
That is not what happened in mediation. I had my attorney fee bill with me, Your Honor, and I shared the number with everybody. But Your Honor, if
So
you look at my attorney's fees, Your Honor, you will see that if there's anything, there's very little, but I don't think there's anything that just goes to my minors. Everything I did was for the benefit of the estate. And I think it's unfair to the minors that the Alberto gets to piggyback on the benefit of what I've done for the whole estate.
Well, my response is Mr. Junior, Alberto Junior, did not commit any bad things, Judge. Any wrongdoing. It was all Doris. So if anybody's going to pay the ad litem, it has to be Doris. It should be Doris.
Your Honor, I'd like to point out also to look in contrast to the attorney's fees that Mr. Ramirez is asking for. The attorney's fees that are being paid back to Ms. Christie will benefit the entire estate, because the estate will not have to incur those additional fees and they'll be reimbursed. Whereas Mr. Ramirez's fees only benefit his client. They don't go to the estate. And so on the one hand, he's criticizing or challenging the fees that Mr. Reiner is claiming, which did benefit the entire estate. At the same time, requesting $47,000 that'll only go into his client's pocket.
But I'm not charging anybody except Doris, Judge. I'm not charging the estate, the kids, or, I'm not charging the brothers of my client for those fees, only Doris. A big difference.
Well, if you did it for the benefit of the estate, then maybe that money should go into the estate.
Well, that'll be the issue for the jury trial.
Your Honor, I think I would ask that the court overrule the objections and move forward. If Mr. Ramirez's client, Alberto Jr., has a complaint, he's with Ms. Christie in settling this. He's free to bring it against Ms. Christie. He participated in mediation. All these things were discussed. And if the court is reluctant to approve it, then I would ask that Mr. Ramirez's client pays for the next mediation and pays some attorney's fees, because Mr. Ramirez has been practicing law 31 years. This mediation was not his first merry-go-round, and he knew that he had to get his client involved. We thought all along, all day long, the various variations of this agreement were being handed to his client, and his client was looking at them. And I think at one point, Mr. Ramirez got off the phone, got off the Zoom, and was talking and meeting with his client.
That's correct.
Mr. Ramirez, is your client viewing the proceeding today? That it's on YouTube, and you could have given him the ID number also. Is your client viewing the
Oh,
proceeding
he
today?
isn't, Your Honor. I'm sorry. He's
I'm
at
sorry?
work. He's at work. He's not viewing this. Do you want to continue this hearing to get him on?
No, I don't want to rehash everything. Let me take this under advisement. Let me, Mr. Ramirez, you send me a proposed order denying the settlement agreement. Mr. Reiner or Ms. Christie, I guess you're the applicant. You'll send me an order approving the settlement agreement.
I think you have one, Judge.
I don't want a lot of details. I want one sentence, two sentence, settlement agreement is approved, attached the settlement agreement. On the restoration order, submit me a proposed order, Mr. Flores, that takes out the language about the separate account. I want it back all in the register of the court. And there's a safekeeping agreement. Is that for signature, Mr. Flores? Are you familiar with what I'm talking about?
That was for the court's approval, but I don't believe the court would sign that. That goes together with the order on restoration of funds, Your Honor.
Any objection to the proposed safekeeping agreement that I've been made favored with a copy on April 23rd, 2021? If you would, Mr. Flores, send me a one-line order approving the proposed safekeeping agreement, or authorizing this, or Ms. Christie, I don't know. I got the order from Mr. Lara, but I would think you need an order authorizing. Oh, it's not even signed by the administrator, Mr. Flores?
The safekeeping agreement?
Yeah.
I can include that if you'd like, Your Honor, but
I think generally the safekeeping is with the party and the court and the bank.
it being Ms. Rios's account, Your Honor. That's why Ms. Rios and the bank were the two parties to that agreement.
Well, Mr. Christie, you figure out what the right thing is. It's either an order signed by the court authorizing the execution of the safekeeping agreement. That these are the terms that are. Do you have a copy of it, Mr. Christie?
Yes, Your Honor, it was circulated.
There has to be an administrative order that authorizes the imposition of a safekeeping agreement and with the court signature. If you draft that for me, Ms. Christie.
Yes.
We looked at it, Your Honor, because I made some changes to a couple of them with Mr. Flores, and he made my changes. So those documents were circulated
Okay.
because I tightened up some language in the safekeeping.
Okay. So, Mr. Flores, you give me the new restoration order, excluding the creation of a separate account.
Yes, Your Honor.
If it's circulated, if I don't have an objection within 10 days, I'll sign it. Ms. Christie, you send me an order authorizing the creation of a safekeeping agreement and what you believe to be the appropriate form. And Ms. Christie, give me an order approving the settlement agreement. Mr. Ramirez, give me an order disapproving the settlement agreement. And
I think you have Ms. Christie's order, Your Honor. I've got one that was filed with it. Order authorizing settlement.
I circulated, but I don't think I filed it because I didn't hear back from anybody. I'll
Okay.
remove the extraneous language and file it.
Your Honor, the order on restoration of funds, it was filed earlier. That one did not include any of the segregation language. I don't know if you're okay with that one as it was presented.
I didn't bother to read it line by line. I just knew I got a second one and I was curious what the difference would be. You're proposing that if I'm not inclined to do the separate account, if I sign the proposed restoration of funds order that I got on April 23rd, that eliminates that as an issue.
Yes, the April 23rd order does not have any segregation language.
So, do you have any objection to my signing that order on restoration of funds?
No, Your Honor.
All right, so I have it. I'll execute that one. The
Okay,
original.
Your Honor.
So send me those as soon as you can, and that'll prompt me to reconsider and do it through an order, which I will.
Your Honor, if I could ask, since this has been somewhat difficult to get these Zooms going in a timely manner, if the court does not approve the settlement agreement, I think we need an order giving us directions. Because otherwise, if you deny the settlement agreement, then we're going to have another hearing with you to get direction of where we're going.
Okay.
And like I said, I would ask that, and I'll be happy to file some that Mr. Ramirez's client, if we have to go back to mediation, I think they should pay some of it.
Okay, so if I approve the settlement, that becomes unnecessary. If I disapprove it, I guess you have to file a piece of paper that prompts me to do something like a motion to reconsider, which, by the way, Mr. Ramirez, you can do too. And I'll either grant either one or the other a hearing or not. And otherwise, I really don't consider a motion to reconsider, but it's a piece of paper that prompts me to consider another setting.
Your Honor, if I may, you asked for real short order. I think you said a couple of lines, but do you mind if I put options as far as you're not accepting the settlement agreement for 1, 2, 3 reasons, and you mark the one you want, because there's either the issue of the attorney fees and then the other 2, paragraph B and paragraph C. I guess we need to know which issue to go forward on and guidance on that, because.
Well,
I don't think,
I'm sorry, Ms. Goods.
I'm sorry, I don't think that we can partially accept an order and make changes to it. I think it's either all or nothing on the settlement agreement.
Absolutely.
Well,
Telling you was like a finding of fact or something like
yeah,
that.
something
Listen,
like-
I mean, it's you give me the shortest order that you can imagine that accomplishes it, and then you give me as many more versions as you want to submit for my consideration.
Okay.
Which I may or may not consider. But, I would benefit from having the proposals before me, and so yeah, you can do that. If
Yeah,
you
I
have-
think, Your Honor, the only thing I think you can do is approve or deny the settlement agreement. I mean, we can't make changes to it because there's
see,
no,
I'm not.
Yeah. you can only approve or deny it.
Right.
Modify this, modify that. It's not, I don't see the court having a role in a settlement agreement. I think it's approved or disapproved, but
I agree.
I would
I
agree.
mean, if it looks like something like findings of fact or conclusions of law or something like that, it's an appellate record kind of thing, we'll include it in there and I'll consider it. But you know, I'm not inclined to modify or change the settlement agreement. It's either.
Right. I don't think the court has the authority to change it, because that would be like making an ultimate determination that you would have after a trial. I think, like Your Honor said,
I see cases where the trial court modifies the settlement agreement proposed by the parties, and that seems so foreign to me. I mean, no, you have a deal, you don't have a deal. That's why the attorney's fees seem so foreign to me. But I mean, if the deal is that he continues to have the attorney's fees, well, then that's a different matter.
Your Honor, we did spend a very long time trying to get Mr. Ramirez to put his fees and try to resolve the fee issue. And that was one of the last things that we were discussing for a very long time, and it broke down. And so we came up with an alternative. We didn't want to destroy the settlement agreement, so we gave him an option of having a hearing in front of Your Honor for his fees.
Well, okay, yeah, that seemed unusual to me, that it wasn't an all or nothing deal. But
I have done on many occasions, Your Honor, where we have said we couldn't agree on attorney's fees, and we've just said, whatever the court's decision is, it's the decision. In fact, and a lot of times we'll say, okay, the party can file their fees and the other party can file their objection and the court will take it up on submission. I can't tell you how many times I've done that.
and the complicating factor here is that Mr. Ramirez filed a jury trial, which all my instinct and all my years has been to always honor a request for a jury trial. Sometimes I've even insisted on jury trials. That's just my way of having parties have to accept the jury verdict.
Well, I think the problem with it, Your Honor, is sure they can look at the reasonableness of it, but the bigger problem is knowing where the cutoff is. What goes to, and a jury's not going to be able to do that.
It doesn't seem like a simple jury verdict. I mean, it just, Mr. Ramirez thinks it's just a blank.
right, that's
how
what
much
the court's
money
instructed.
to give Mr. Ramirez, and I mean, that's not a jury issue, but it weighs heavily on me not having it resolved. But
Well,
I don't know if this is going to poison the possibility. By the way, poison the possibility of settling on everything else. That Do you
Well, I
want
think we're stuck in limbo until we know if we're gonna have to go try this case, Your Honor.
I think the
How
trial
about-
should
Yeah,
be.
you're not going to be involved in the attorney's fees. That would be an issue.
No, sir. Your Honor, that's not my issue. And we specifically put language in there that Mr. Ramirez's client couldn't come back to the estate and that he couldn't go to the bonding company.
That it's strictly between Mr. Ramirez and Mr. Flores's clients.
So your scenario about having to come back, whether you're going to try the case or not, is in the scenario of disapproving the settlement.
Yes.
That is not an issue of approving the settlement.
No, that's not an issue. We're done.
Yeah.
And then the only thing we have left, Your Honor, is to divide the rest of the assets. We have three choices. We can divide them in kind and split them up. We can do a partial. Ms. Christie can sell, or the third alternative is she can just say, I'm closing it down. You each got an undivided interest. If you want a partition, go over to the district court.
Well, I may be more inclined to give you the benefit of some, I may in light of all this history, may be more inclined to do a sale now that everyone understands that Mrs. Rios doesn't get the money from the proceeds of the sale. She may not be willing to execute deeds, but that's the only way that sales can happen.
Well, I think, Your Honor, when jointly owned property is there, you have authority to sell jointly owned property with notice to Ms. Rios. The
Right.
court, there's code sections that give you the authority to do it.
I know that, but the title companies never going to do it.
Yeah, well, I've had to get court orders saying that the property is to be sold.
Oh, okay. Well, I thought the title company would be the end of the issue, but I do agree that there's case law all over the place that the other spouse's stuff sold. I mean,
Yes, you are correct, Your Honor.
it's just sold.
Yeah.
So if that's a viable possibility, I thought that you were going to hit the wall with the title companies, and that was going to be the end of the issue. If this is where the value-added aspect of your participation has been beneficial, Mr. Reiner, and I appreciate it.
Well, I appreciate that too, Your Honor. It's not the means which I would want Miss Christie to have to go fight through the title company. I think, though, if we had an opportunity, I think we could sit down with Mr. Flores's client and Mr. Ramirez's client and try to take a shot at dividing this property. I don't even think we need a mediation for that. My problem is I need to speak to a realtor, look at the appraisals and see what this property's worth so my kids don't get harmed.
So you're not so persuaded this is going to taint the following. Well, maybe we'll take your aspect, but it may Mr. Ramirez's. I guess Mr. Ramirez will have to decide it for himself.
Yeah, and Mr. Ramirez has shown an interest, Your Honor, into dividing up the property too.
And you okay.
So I think we can get it done if the court gives us a time period and says, you guys, you either go get it done 30 or 45 days, or you go to mediation within 30 days. You know, I don't want to go to the expense of mediation, but I think once we start talking about it, Miss Rios can decide, does she want to buy out the kids on the house because she only owns half? Or, you know, at the end of the day, when Miss Rios passes away, Alberto Jr. will get his interest.
Okay. All right. If y'all send me your respective orders, I'll deal with them in due course as soon as I can.
Okay.
For y'all's information, Mr. Flores, I was made aware from Ms. Rowland that your father-in-law is ill.
Oh, yes, Your Honor. He's on life support right now.
Okay. Well,
Sorry to hear that.
I left on you, but express my
I'm sorry, your father-in-law is who, Thomas?
Leo Lara.
Oh, I didn't know that relation.
He's in the hospital, seriously ill. So we wish him the best. Please,
Wish you was. We'll say keep him in our prayers.
Yeah, for sure. Sorry to hear that.
your wife and his family. Okay, if that's all, I'm gonna end the proceeding. Y'all have.
Thank you, Your Honor. Thank you, Roland.
All right.
Thank you.
Thank you.
Thank you, everybody.
Thanks.